5 seconds to go. Start. The basic requirements ingredients to bring home the accusations under the alleged offences are hereunder. Causation of hurt by another person, that he caused such hurt voluntarily, that such a case is not covered under section 334 IPC. Intentionally putting a person in fear of injury to himself or another, dishonestly inducing a person so put in fear to deliver to any person any property or valuable security, entrustment of the property or any dominion over property with accusation, the person entrusted dishonestly misappropriating or converting to his own use that property, or dishonestly using or disposing that property in violation of any direction of law prescribing the mode in which such trust is to be discharged, or of any legal contract express or implied which he has made touching the discharge of such trust, or wilfully causing sufferance to any other person so to do. The essential ingredients to constitute an offence under section 423 IPC is that the sale deed or deed subjecting an immovable property to a charge was contained a false statement relating to the consideration or relating to the persons or whose use or benefit it was intended to operate. Thus, it is evident that section 423 IPC deals with twin specific frauds in the matter of execution of deeds or instruments of transfer or charge, idist, false recital as to consideration, or false recital as to the name of beneficiary. Virtually, the offence under section 467 is an aggravated form of the offence under section 466 IPC. The essential ingredients to constitute the offence punishable under this section are commission of forgery, that such commission of forgery must be in relation to a document purporting to be a valuable property or a will or an authority to adopt a son, or which purports to give authority to any person to make or transfer any valuable security, or the receive the principal, interest or dividends thereon, or to receive or deliver any money, movable property or valuable security, or any document purporting to be an acquittance or receipt acknowledging the payment of money, or an acquittance or receipt for the delivery of any movable property or valuable security. Commission of forgery, that he did so intending that the document or electronic record forged shall be used for the purpose of cheating. To constitute the said offence, there must be deception, that is, the accused must have deceived someone, that by such deception the accused must induce a person to deliver any property, or to make, alter, destroy a whole or part of the valuable security or anything which is signed or sealed and which is capable of being converted into a valuable property, or that the accused must have done so dishonestly. The offence punishable under section 120B IPC to constitute criminal conspiracy, there must be agreement between two or more persons. The agreement should be to do or cause to be done some illegal act, or some act which is not illegal by legal means, provided that where the agreement is other than one to commit an offence, the prosecution must further prove, or that some act besides the agreement was done by or more of the parties in pursuance of it. Now the question is whether the allegations in the aforesaid application are sufficient to constitute the alleged offences. We have already extracted the said application filed by the respondent against the appellants in its entirety. At the outset, it is to be noted that in the affidavit accompanying the application, the respondent had stated thus: I have not placed this incident before any court heretofore. In the application, obviously, it is stated that he is one of the trustees of Bagla Sundari Memorial Trust at Basunagar, Madhyagram, and under the said trust there is a high school by name of Rosebank Educare, and he is the secretary of the said school. The recital in paragraph 2 of the application filed by the respondent would reveal his case that the accused persons kept him in dark and without giving any information by strengthening the said trust deed illegally got the same registered on 12th July 2016 and removed him from the said post. It is in this context that the aforesaid statement in the aforesaid affidavit assumes relevance. It is the case of the appellants that in regard to his removal from the post of secretary of the school, the respondent had instituted title suit number 363 of 2015, praying therein for a declaration that he is the secretary of the school, and the said suit is still pending. Stop.